There's a truth about American families that almost nobody wants to say out loud. When a parent dies without a plan, really dies, with no will, no clear instructions, no conversation had while they were still alive, the family that loved each other at the funeral is not, in most cases, the same family that exists 3 years later. Something breaks. Not always loudly, sometimes silently. A brother and sister who haven't spoken in 4 years. A grandchild who was supposed to receive something and didn't. A quiet lawsuit between cousins that nobody outside the family knows about. A Christmas table that went from 12 people to 6. Let me show you the blueprint. Because planning for what happens to everything you own, your money, your house, your belongings, your wishes, is not a task you do for yourself. You'll be gone. You won't witness any of it. It's a task you do for the people you love the most. And it's the single most loving financial decision you will ever make. Let me start with a number that, when you see it clearly, changes the way you think about this entire conversation. Roughly 2 out of 3 Americans over the age of 50 do not have a basic will. 2 out of 3. That's not a small minority. That's the majority. The majority of Americans who have spent decades building a life, accumulating a home, retirement accounts, personal belongings, family stories, meaningful objects, have made no written plan for what happens to any of it when they're gone. And it's not because they don't care. It's not because they're lazy. It's not because they're bad parents or irresponsible spouses. It's because estate planning is one of those things that lives in the corner of your mind labeled, "I'll get to it." And nobody ever gets to it until something happens. And then it's too late. Now here's what actually happens when an American dies without a will. The legal term for it is dying intestate. And when someone dies intestate, the state, not the family, not the deceased, the state, decides what happens to everything. Every state has its own set of default rules, written by legislators decades ago, applied uniformly to every person who dies without documentation. Those rules rarely match what the deceased would have wanted, but the deceased isn't there to argue, so the rules win. In most states, if a married person dies without a will, the money doesn't automatically all go to the surviving spouse. It gets split, often between the spouse and the children in predetermined percentages, which sounds fair on paper, but in real life can mean that a grieving widow suddenly discovers she owns only 60% of the house she's lived in for 30 years, and her 3 adult children own the other 40%. Together, equally. And if any of those children want to force a sale, they can. If any of those children are in debt, creditors can come after that share. If any of those children divorce, their spouses may have claim to it. The surviving parent, who spent a lifetime building that home with the person they loved, suddenly has to negotiate with their own children about whether she gets to keep living in it. This is not an unusual story. It happens thousands of times every year in America. This is where most people get it wrong. They assume that their family will just work it out, that everyone loves each other, that nobody would be petty about money, that people will do the right thing. And in quiet, simple families, sometimes that's true. But more often, what gets exposed after a death is not the love. It's the accumulated, unspoken tensions of decades that nobody had the courage to discuss while the parent was still alive. The sibling who helped take care of mom for the last 3 years, while the others visited once a year at Christmas, expects to receive something extra. It's not in writing. It doesn't exist legally, but in her mind, it's owed. The sibling who got a loan from dad 15 years ago to start a business, a loan that was never formally documented, never formally repaid. The other siblings remember. Now that dad is gone, they want that factored in. The child who was given the family cabin verbally years ago. Someday it's yours, has no paperwork to prove it. Another sibling who never heard that conversation thinks the cabin should be sold and divided equally. The grandchild who was promised the grandmother's wedding ring watches as another cousin walks out of the house wearing it, and nobody knows what was actually intended. All of these situations are invisible while the parent is alive. They're tensions that live under the surface of family gatherings for years, mostly dormant, mostly manageable. And then the parent dies, and the absence of clear instructions allows every one of those tensions to surface at once, at the worst possible moment. During grief, without the person who could have clarified anything still available to speak. This is where families break. You don't need more money. You need a better plan. And the plan, when it comes to estate planning, is not primarily about the money. It's about reducing the number of questions your family has to answer without you. Every decision you document while you're alive is a fight your family won't have to have after you're gone. Every wish you put in writing is a conversation your children won't have to guess at. Every relationship you protect through clear instructions is a Thanksgiving table that stays full decades later. But to really understand what's at stake, you need to see the specific mechanisms by which families actually fall apart after a death. Because it's not usually what people imagine. It's smaller, quieter, and far more common than the courtroom dramas you've seen on television. Let me tell you how families actually break after a death, because the reality is almost never what people expect. Most Americans, when they imagine a family falling apart over an inheritance, picture a dramatic courtroom scene, lawyers shouting, a greedy relative trying to cut someone out, a dramatic revelation in the reading of the will. That's Hollywood. Real family breakdown is much quieter, much slower, and much more insidious. It starts with what's called the probate process. Probate is the legal procedure by which a deceased person's estate gets sorted out under the supervision of a court. If there's no will, probate takes over entirely. The court appoints an administrator. The administrator identifies the assets. Creditors have a period of time to file claims. The estate gets inventoried. Debts get paid. And eventually, what's left gets distributed according to state law. Here's what nobody tells you about probate. It's slow. Painfully slow. The average probate process in the United States takes somewhere between 9 and 18 months, and complex cases can take years. During all of that time, the family is essentially frozen. They can't sell the house. They can't access the bank accounts. They can't divide the belongings. Everything sits in legal limbo while paperwork moves through a court system that has no urgency about any individual family. It's also expensive. Probate costs typically run between 3 and 7% of the total estate value. On a $500,000 estate, that can be $20,000 to $35,000 of your family's inheritance going to lawyers, court fees, and administrative costs. Money that's simply gone before anyone sees a penny. And it's public. Probate is a public record. Anyone who wants to can walk into the courthouse and look up what was in your estate, who got what, and what the arguments were. Your neighbors, your ex-business partners, distant relatives you didn't even know existed. All of them can see your family's private business laid bare for anyone curious enough to look. This is where most people get it wrong. They think the worst part of dying without a plan is the money being distributed incorrectly. The worst part isn't the money. The worst part is the experience. The months and years of frustration, delay, cost, and forced public exposure that the family has to endure while they're simultaneously trying to grieve. Now, layer on top of that the human emotional reality. One of the children is managing all of the paperwork because nobody else has the time. She's making weekly trips to the lawyer's office, dealing with the utility companies, cleaning out the house, organizing the belongings. Her siblings are grateful at first. Then they start to wonder if she's taking things that weren't hers. Then they start asking uncomfortable questions. Then they start wondering if their inheritance is being handled fairly. The sister who's doing all the work starts to resent the siblings who aren't. The siblings who aren't helping start to mistrust the one who is. And none of them had any of these feelings toward each other 2 years earlier. There's another pattern that I've seen destroy American families more than any other. I want you to pay close attention to this one because it's so common and so preventable. It's the pattern of verbal promises that were never documented. Mom told me 20 years ago that I'd inherit her wedding ring. My sister doesn't remember that conversation. My sister wants the ring because it was promised to her daughter. The ring is now sitting in a box with no label. 2 adult siblings who have loved each other their whole lives are about to have a fight about a piece of jewelry that both of them genuinely believe was promised to them. Dad told me over the years that the lake cabin would be mine because I was the one who fixed it every summer. My brother doesn't remember any of that. He remembers Dad saying we'd share it. The cabin is worth $80,000. Both brothers now believe, genuinely, that the cabin belongs to them. One of them is going to feel cheated no matter what happens. These aren't malicious people. They're not trying to steal from each other. They're trying to honor what they remember their parents wanted. And because nothing was written down, there's no way to resolve whose memory is correct. The fight isn't about greed. The fight is about grief, about love, about wanting to preserve a piece of a parent who's gone. And because there's no documentation, the fight has no end. You don't need more money, you need a better plan. And the plan, in its simplest form, is nothing more than this. Write it down. Everything. What you own. What you want to happen to it. Who gets what? Who makes decisions? Who speaks for you if you can't speak for yourself? And then make sure the people who matter know where those documents are and how to access them. That's it. That's 90% of estate planning. Written clarity, properly stored, legally executed. And yet, 2 out of 3 Americans over 50 still haven't done it. But before we get to the how, there's one more dimension of this conversation that most people never consider. The dimension that affects a much more immediate decade of your life than the moment of your death. And for most Americans in their 40s today, this dimension matters more than any will. It's the dimension of incapacity. And I want you to sit with that word for a moment, because incapacity is not something most Americans in their 40s think about seriously. We think about death as the thing that happens eventually, someday, far in the future. But incapacity, the state of being alive but unable to make decisions for yourself, can arrive at any age. A car accident, a stroke, a sudden illness, a diagnosis that changes everything. And here's what almost nobody knows. The moment you become incapacitated without having signed the right documents, your entire family enters a nightmare that most estate planning videos don't talk about. Your spouse, the person you've lived with for decades, does not automatically have the legal right to make medical decisions for you. Not in most states, not without specific paperwork. Your adult children do not automatically have access to your bank accounts to pay your bills while you're in the hospital. Your business partners cannot automatically sign documents on your behalf to keep the business running. Every single one of these things requires specific legal authorizations signed while you are still mentally competent, granting specific people the specific authority to act on your behalf. Without those authorizations, your family has to go to court in the middle of whatever crisis just happened and ask a judge to grant them permission to take care of you. The process is called guardianship or conservatorship. It takes weeks, sometimes months. It costs thousands of dollars in legal fees. It's emotionally brutal because you have to demonstrate publicly and in legal proceedings that the person you love is incapable of handling their own affairs. And at the end of it, a judge, a stranger who has never met you, gets to decide who takes care of your finances, your medical decisions, and your daily life. Meanwhile, nobody is paying your mortgage, nobody is managing your retirement accounts, nobody is making medical decisions about your care. Your family is frozen, watching you lie in a hospital bed, unable to act while the legal machinery slowly catches up. All of this is preventable with 3 documents that most Americans have never heard clearly explained to them. The first document is called a durable power of attorney for finances. It's a legal authorization that says, if I become incapacitated, this specific person has the authority to manage my finances on my behalf, pay my bills, access my bank accounts, handle my investments, sign documents, whatever needs to happen to keep my financial life running smoothly. You pick the person. You sign it while you're healthy. You file it appropriately. And if the worst happens, the person you chose can act immediately without court involvement. The second document is called a healthcare power of attorney, sometimes called a healthcare proxy or advance directive. This is the companion document for medical decisions. It designates a specific person, again chosen by you in advance, to make medical decisions on your behalf if you can't make them yourself. It also typically includes your preferences about life-sustaining treatment, resuscitation, and end-of-life care. These preferences matter enormously, not because they give you control after you're gone, but because they take the burden of impossible decisions off your family's shoulders. A wife who has to decide whether to remove her husband from life support shouldn't have to guess what he would have wanted. He should have told her in writing years before. The third document is called a living will. Some states combine this with the healthcare power of attorney, some separate them. The living will specifies your wishes about specific medical situations. Do you want to be kept alive on machines indefinitely? Do you want aggressive treatment for terminal illness or palliative care? Do you want to be an organ donor? These are intensely personal questions that deserve intensely personal answers. And the only time to give those answers is while you're healthy enough to think about them clearly. Together, these 3 documents, often called an incapacity plan, cost somewhere between $300 and $1,200 to have drafted properly by an attorney. For that money, you protect your family from the nightmare of having to go to court while you're lying in a hospital bed. You keep them focused on your recovery rather than your paperwork. And you give them the clarity of knowing in specific written terms what you would want them to do on your behalf. This is where most people get it wrong. They assume that being married or being someone's child or being close to someone emotionally grants automatic legal rights. It doesn't. American law is surprisingly specific. Without documentation, your closest relationships don't carry the legal authority most people assume they do. And the moment of discovery, the moment you learn this matters, is almost always the worst possible moment to learn it. If you fix this, everything changes. You don't need more money. You need a better plan. Now I want to take you through the 4 core estate planning documents every American over 40 should have. Not just the incapacity documents we just talked about, the full structure. Because once you understand all 4, the entire thing starts to feel manageable, not overwhelming. The 4 core documents. Let me walk you through them in the order they actually matter for most American families. Document 1 is the will, the foundational document, the one everybody has heard of, but 2 out of 3 people over 50 still don't have. A will does 3 essential things. It specifies who gets what after you die. It names the person responsible for executing your wishes, usually called the executor or personal representative. And critically, if you have minor children, it designates who would raise them if both you and the other parent died. Let me stop on that last point for a second, because that alone is a reason for anyone with young children to have a will. If you and your spouse die in a car accident next month and you have no will, a judge, not a person who knows your family, not someone who knew your parenting values, a judge will decide who raises your children. That judge will listen to family members' petition for custody. They'll make a decision based on legal factors. And the children you spent years shaping will be handed over to the outcome of a courtroom procedure, rather than to the specific people you would have chosen. No parent, if they stopped and thought about it clearly for 5 minutes, would want that. And yet millions of American parents leave that exact decision in the hands of strangers because they never wrote a simple document. A basic will can be drafted for $300 to $800 by a licensed estate attorney. It can be updated whenever your life circumstances change. It's the single most important document in your entire estate plan if you have children, property, or specific wishes about anything you own. Document 2 is a living trust. This is where the conversation gets slightly more technical, but stay with me, because this document is one of the most underused tools in middle-class American estate planning. A living trust is a legal structure that holds your assets during your lifetime, manages them if you become incapacitated, and distributes them after your death, all without going through probate. Let me say that again. Without probate. No court oversight. No 18 months of delay. No 3 to 7% in fees. No public record. The trust simply transfers to the successor trustee you named, and that person immediately has legal authority to handle your estate according to your documented wishes. For many American families, particularly those with a home, retirement accounts, and meaningful savings. A living trust is actually more important than a simple will, because it's what protects the family from the probate experience we talked about earlier. That painful, slow, public, expensive process that breaks so many grieving families. A properly funded living trust sidesteps it entirely. A living trust typically costs $1,500 to $3,000 to establish, depending on complexity. It's more expensive than a basic will, but for most middle-class American families with real assets, it pays for itself many times over in avoided probate costs and avoided family trauma. Document 3 is the durable power of attorney for finances, which we already discussed. The financial authorization that kicks in if you're alive but incapacitated, essential for anyone over 40. Document 4 is the healthcare power of attorney combined with a living will. The medical companion to the financial authorization, equally essential and equally overlooked. Now, here's where most people get it wrong. They hear this list of 4 documents and feel overwhelmed. They think it's going to be expensive, complicated, take months, and require them to make dozens of difficult decisions, so they put it off, again, for another year, or 3, or 10. The reality is much simpler. A competent estate planning attorney can draft all 4 of these documents in a single meeting, with a follow-up signing a few weeks later. Total time commitment from you, the client, is usually somewhere between 4 and 6 hours across 2 or 3 appointments. Total cost for a standard middle-class family is typically somewhere between $2,000 and $4,000. Sometimes less in rural areas, sometimes more in major cities. For the money a middle-class American family spends on a single-family vacation, you can buy lifetime protection against the entire spectrum of incapacity scenarios, probate nightmares, family disputes, and legal ambiguity. It's not expensive. It's not complicated. It's just uncomfortable to think about, which is why people avoid it. And here's what I want you to really hear. These documents, once created, don't sit in a drawer forever. They get updated. When your life changes, a marriage, a divorce, a new child, a death in the family, a move to a different state, a significant change in your financial situation, you revisit the plan, you tweak it, you keep it current. An estate plan is a living document, updated periodically over the decades, but the version of the plan you need most is the first one, the foundational plan. The one that transforms you from someone who has nothing in writing into someone who has a basic structure in place. Everything else is refinement on top of that foundation. If you fix this, everything changes. You don't need more money, you need a better plan. But there's one more layer to this conversation. A layer that most estate planning lawyers don't even discuss with their clients, because it's not strictly a legal matter. It's a human one, and for most American families, it matters more than any document. It's the conversation, the one you haven't had yet, the one almost nobody has, the one that, if you had it before any of the legal documents were signed, would do more to protect your family than any piece of paper ever could. Let me explain what I mean. You can have the most beautifully drafted estate plan in the world. Every document signed, every asset titled correctly, every beneficiary properly designated, every wish written down in legally binding language. And still, your family can end up in chaos after you're gone, because nobody had ever actually talked about any of it out loud while you were still alive. Here's what I've watched happen in American families over and over. A parent dies, The adult children gather. The lawyer reads the will, and something in the will surprises one of the children. Maybe a piece of jewelry went to a sister instead of a daughter. Maybe the vacation home was left to one child instead of split between all three. Maybe a larger portion went to the child who was already wealthy, and a smaller portion to the child who was struggling. Whatever it is, it surprises someone. And because that child learns about the decision at the worst possible moment, in a lawyer's office after a funeral while grieving, it lands as a wound, not as a decision. The child thinks, "Why didn't Mom tell me this is what she wanted? Why did I have to find out this way? Did she not trust me enough to explain her reasoning? Did she think I'd argue with her? What did she really think of me?" Those questions live in the child's mind for years, sometimes for the rest of their life. And those questions are what actually damage families, not the money, not the objects, the absence of explanation. This is where most people get it wrong. They think that keeping the estate plan secret protects them from difficult conversations while they're alive. They're wrong. Keeping it secret just shifts the difficult conversation to a moment when you're not there to explain, and without you there, the conversation gets distorted, weighted with grief, and amplified by every old family dynamic that never got resolved. The solution is to have the conversation while you're alive. Not a formal reading, not a dramatic announcement, just a simple, honest, adult discussion with the people you love. Something like, "I want you to know how I've set things up, not because anything's going to happen anytime soon, but because I want you to hear it from me, and I want you to understand my reasoning, and I want you to have the chance to ask me questions while I'm still here to answer them." That conversation is uncomfortable. Of course it is. We don't like talking about our own death. We don't like confronting the realities of inheritance. We don't like the possibility that our children might be upset by our decisions. So we avoid it. We tell ourselves they'll understand later. They'll figure it out. It'll be fine. But the families that stay close after a parent dies are almost always the families that had the conversation. The families where mom or dad sat everyone down at some point in their 60s or 70s and said, "Here's what I'm planning. Here's why. Here's what I'd like you to do. Let's talk about it." When the conversation has been had, the reading of the will feels like a confirmation of things already discussed. When it hasn't been had, the reading of the will feels like a revelation from the grave. The first builds family unity, the second almost always damages it. I want to tell you something specific that most estate planning experts don't emphasize enough. The conversation is more important than the documents. The documents create legal clarity. The conversation creates emotional clarity. And in most families, emotional clarity is what prevents the long-term damage. A family can accept an uneven inheritance when they understand the reasoning. They cannot accept being surprised by it at their worst moment. If one child receives more because they took on more caregiving responsibilities, explain that. While you're alive, out loud, to everyone. So the other children understand it's not about love. It's about labor already performed. If one child receives less because they've already been helped in other ways during your lifetime, explain that too. Don't leave those explanations for a lawyer to read after you're gone. You're the only person whose voice can actually carry the weight of that reasoning. You don't need more money. You need a better plan. And the best estate plan in American life is not just documented, it's also discussed. It lives both on paper and in the memories of the people who will one day inherit from you. When those two things match, when the paperwork reflects conversations you've had with your family, the plan works. When they don't match, when the paperwork is the first anyone has heard of your wishes, that's when the family breaks. Now, if you've been watching this video and thinking, this sounds like a lot, I want to tell you something that might change how you feel about the whole thing. There's a specific order in which to do all of this, and that order matters, because doing it in the wrong order can actually cause problems. And doing it in the right order makes the whole thing feel completely manageable. Before I give you the order, and trust me, it matters, I want to pause for a moment. If you've made it this far into the video with me, if you've stayed through a conversation about your own death, your family's conflicts, and the documents most Americans avoid their entire lives, if you're still here and still willing to think clearly about this, I want to invite you to subscribe to this channel and walk with us every single day. This is the kind of conversation we have here. Uncomfortable, necessary, honest. The conversations no one else is willing to have with you in plain language. And I want to say something directly. Talking about death is one of the few things in American culture that almost nobody does well. We're good at talking about money. We're good at talking about careers. We're even sometimes good at talking about health. But death, our own death specifically, remains one of the last taboos. And the price of that taboo is paid by the people we leave behind. They're the ones who inherit the mess we didn't clean up because we couldn't bring ourselves to look at it. You looked at it tonight. That puts you ahead of most of your neighbors. It puts you ahead of most of your co-workers. And it puts you in a position to actually do something about it in the coming weeks, rather than leaving it as another item on a list you'll never get to. Now let me give you the order. Step 1 is the incapacity plan, the durable power of attorney for finances, the healthcare power of attorney, the living will. These 3 documents come first because incapacity can happen at any age, and the window for signing them closes the moment you lose mental competency. Signing these 3 documents is the most urgent piece of estate planning for every adult in America. More urgent than the will, more urgent than the trust. You need them today, not someday. Step 2 is the will. If you have children, this is non-negotiable. The guardianship designation alone makes a will one of the most important documents a parent can sign. Even if you don't have children, a basic will specifies your wishes and avoids default state distribution rules that rarely match what you actually want. Step 3 is the living trust, if it makes sense for your situation. For Americans with modest estates, no home, limited savings, no complex assets, a will alone may be sufficient. For Americans with homes, retirement accounts, real estate, or assets totaling more than a few $100,000, a living trust almost always pays for itself through avoided probate costs and avoided family stress. Your attorney can help you decide which path makes sense. Step 4 is the conversation. Once the documents are drafted, sit down with your family. Not to read the documents, not to go through the legal details, just to communicate the essence. I've put things in place. Here's generally how things are structured. Here's what I'd like to happen. If anything happens to me, this is who has authority, and these are the values I want to guide any decisions. Step 5 is the storage and communication plan. Your documents are worthless if nobody can find them. The original copies should be kept somewhere specific, usually a secure location at home, with a copy at your attorney's office, and in some cases a safe deposit box. The executors and powers of attorney need to know where to find everything. They need to know the attorney's contact information. They need to know how to access your digital accounts. They need to know where critical paperwork lives. One small but vital point I've seen families struggle with: do not keep your original will in a safe deposit box that only you can access. Because when you die, the bank often won't let anyone into that box without a court order, which creates exactly the probate delay you were trying to avoid. Step 6 is the review schedule, every 3 to 5 years, or whenever something major changes: a birth, a death, a marriage, a divorce, a move to another state, a major financial shift. Your plan is not a one-time project. It's a living document that evolves with your life. Treat it accordingly. If you fix this, everything changes. You don't need more money. You need a better plan. And here's the final thing I want to say about estate planning, because it might be the most important thing in this entire video. The plan you create is an act of love, not a task on a list, not an obligation to fulfill. An act of love. Every document you sign is one less argument your children will have after you're gone. Every conversation you have is one less wound you leave them to bear alone. Every clarification you provide is one more piece of your voice that continues to guide them after you've stopped speaking. The gift you leave your family isn't really the money or the house or the objects. It's the clarity, the organization, the evidence that you cared enough to think about them even in the one situation where you couldn't be there to help them yourself. That gift is irreplaceable, and the only time to give it is now. There's a scene I want you to carry with you after this video ends. It's 3 years from now, maybe 5, maybe 15, a Tuesday afternoon. Your daughter is sitting at her kitchen table, a cup of tea in front of her, late morning light coming through the window. She has a folder open in her hands. The folder you put together when you finally did the thing you've been putting off for decades. Inside the folder, everything is clear. She knows where your will is. She knows who your attorney is. She knows what your wishes were. She's read the letter you left her. The one that wasn't a legal document, just a letter in your own handwriting, explaining the reasoning behind a few of the decisions. She's sitting at that table feeling something she didn't expect to feel. Gratitude. Not for the money you left, not for the objects, for the absence of chaos, for the way your final gift to her was the simplest one of all. Clarity. Her brother is not angry at her. Her sister is not suspicious of her. The family is not divided over a lake house. The family is not fighting over a piece of jewelry. The family is grieving, yes, because you're gone. But the grief is clean, uncomplicated by legal battles or secret resentments or years of wondering what you really wanted. That scene is not accidental. It's not something that just happens to some families. It's something you build deliberately, decades in advance, with paperwork, with conversations, with the willingness to sit down once, uncomfortably, and do the thing that almost nobody wants to do. And now picture the alternative. Same daughter, same kitchen, same late morning light, but no folder, no documents, no letter. She's on the phone with her brother. They're arguing again about something that happened at the lawyer's office last week. Her sister hasn't spoken to either of them in 2 months. The house your daughter grew up in is stuck in probate, tied up in a legal process none of them fully understand. A relative has hired their own attorney to challenge something. Nobody knows what mom really wanted because she never told anyone. The last version of her that her children have, the version that exists in their memories now, is not the version of her sitting at the kitchen table explaining her decisions calmly. It's the version of her absent, silent, unable to clarify anything. Both scenes are possible. Both are happening right now in millions of American families, and the only difference between them is whether or not the version of you watching this video tonight decided to do something uncomfortable and finite in the coming weeks. Estate planning is not about death. That's the biggest misunderstanding Americans have about it. Death is the trigger, but the gift is for the living. The gift is the protection you give the people you love from the institutional machinery that would otherwise grind them down during the worst moment of their lives. The gift is the clarity you give them about what you wanted. The gift is the family dinners that still happen, decades after you're gone, because nobody walked away from the table with a wound that never healed. That gift costs between $2,000 and $4,000, plus a few hours of your time, plus one honest conversation with the people you love. That's the entire price. That's the total investment required, and what it buys is peace, real peace. For the generation that follows you, for the grandchildren you may never meet, who will nonetheless benefit from the family that stays intact because you took the time to do this right. Start this week, not someday. This week. Call an estate planning attorney. Schedule the first consultation. Most offer free initial meetings. Walk in, tell them your situation honestly, and let them guide you through the steps. It will feel manageable. It will feel less scary than you think. And 3 or 4 months later, you'll be done. For a decade or more. Until your life changes enough that the plan needs updating. Now, before you go, let me ask you for 3 things. First, if anything in this video hit you tonight, subscribe to this channel. Walk with us. The conversations here only get deeper. The next video in this series is going to be about the decision that silently decides your financial future. The 3 big buckets where you put your money and why most Americans over 40 have them dangerously unbalanced. You don't want to miss that one. Second, share this video with 5 people. 5 people in your family. 5 friends. 5 people you care about who have not yet done this. You might be the reason years from now that a family somewhere stays whole. That's worth sending a link. And third, leave me a comment, an honest one. Tell me what stopped you from doing estate planning so far. Tell me what finally pushed you to think about it differently. Tell me what you want me to cover next. Every deep video we make starts with someone asking the right question. Take care of yourself. Take care of the people counting on you. And remember, the last gift you give your family is not the money you leave. It's the chaos you prevent. And that gift is built while you're still here to build it.